Document Tingz, bringing truth to the light. Paper trail strong, yeah, we reading it right. From the docket to the drop, every case, every scene. I'm your courtroom reporter with the facts in between. Yeah. Document Tingz, bringing truth to the light. Paper trail strong, yeah, we reading it right. From the docket to the drop, every case, every scene. I'm your courtroom reporter with the facts in between. Yeah.
All right, and we are back for part 3. All right. I want to make sure y'all see my copyright disclaimer under section 107. Let's get that back on the screen, and also my QR code. And also, again, disclaimer. There will be, maybe, could be a word that I stumble upon. But it's all right. It's not that deep, y'all. It is not that deep. But anyway, let's continue. Miss Dixon. So the court, let's put the effort at pre-admitting trial exhibits. Let's put that to the side and understand that we're going to finish that task on November the 10th. However, late in the night, it takes us. And I will expect, let me repeat, I will expect, as required by our local rules, that the parties will have conferred as to each exhibit in an effort to reach agreement on any objections. Mr. O'Sullivan. Yes, Your Honor. The court, very good. So let's move on then to witnesses. Are there any objections to any proposed areas of inquiry as to any witnesses? I don't have sidebar conferences, just so the parties are aware. So if you have an objection that requires a speaking objection, and by the way, Ms. Dixon, we don't have speaking objections here in the Southern District of Florida. You have to reference a rule or say a word, but there are not sentences going on and on and on about objections. These are what we call speaking objections. So if there are any areas of inquiry you know you're going to be objecting to, let's address it now. I don't want to be excusing the jury in order to have protracted conversations with counsel. Any issues with regard to the witnesses for trial? Ms. Dixon, the witness list is pretty much ongoing. They still are deposing people. And so I'm not sure what the content of their witness list is actually. Mr. O'Sullivan, I think in the category of are there any special areas that we would want to hash out in terms of we wouldn't go with the witness? I don't think we have anything besides what was in the step, which is they're not going to bring up impermissible character stuff. But I don't think we've identified anything beyond that. And I think the remaining witnesses have been in progress, the third party witnesses, for a long time. And they're going to result in depo transcripts that are going to be a very small part of the trial, but important. And they're proceeding on their own schedule, but they'll be done in time. The court. So if your intention is to read from our show depositions to the jury, we need to hash out objections to deposition designations. Mr. O'Sullivan. Yes, in all of the designations from our side. But these last two people are in the other side has, and we haven't completed our conferral on the designations, but they're there. And we're open to any completeness suggestions they have. The court. All right. So when we reconvene on the 10th, I need to have on the table for discussion any objections to deposition designations so I can rule on those prior to trial. All right. Mr. O'Sullivan. Yes, Your Honor. The court. Okay, very good. So then let's move on to the jury instructions. Have you all conferred on these? Mr. O'Sullivan. Most of our conferral has been with the defense counsel who is not here. I think Mr. McLamont. You have from the filing our proposed instructions, and then deferring ones from the other side. The one issue that I would flag that we would bring up is Mr. McLamont readily brought up the fact that we kind of have one fact pattern there. Well, here. And when it unfolded in all of its scope, in scale and detail, it wasn't in causes of action like defamation or intentional infliction of emotional distress or deep fake corn. Those are kind of construct we're putting on it. And where it becomes potentially confusing, and hopefully we address this, is on the damages. The damages, to be fair, are kind of unified. It's an overall effect of her all, well, on her of all of this. It would be very hard to credibly pull out the well, y'all see that word corn, circulation or this particular rant or string. And I think we didn't get all the way there with Jeremy. But from what I've been able to determine, at least one safe way to deal with double damages, which was his overlapping, his complaint is just to have one damages, thing on the verdict form at the end, not by cause of action. And we didn't do that in our submission. It hadn't come up yet, but we're open. We don't want double dipping. This is not primarily about commercial damages. This is really about sort of vindicating the underlying reality. And so we don't want confusion. And I think it is really one unified damage. So we would propose dealing with at least his version of the objection by taking damages questions out of the counts and putting them in just at the end. But we hadn't heard from Rhonda on that. The court. So that's an issue for the verdict form. I take it. Mr. O'Sullivan, I think it would. You would confirm the jury instructions as well in terms of just, again, separating sort of the details of each count and attaching to damages. But yes, the concept is we're only asserting one overall damage. We do have distinct causes of action, and we have an entitlement to pursue those, but not to get double recovery. And I think the best practice is always to have a line just saying, don't pay twice for anything. The court. So let's begin then with the jury instructions. I saw the first area objections appear at page 5 of docket entry 135. Am I working off the correct set, or do y'all all have something more updated? Miss Molino, that's the correct set, Your Honor. The court. So I need to describe the case to the veneer when we're engaged in jury selection, and at the start of the trial give these instructions. We're competing descriptions. So how do we move past this? Mr. O'Sullivan, I'm sorry, Your Honor. The court, you all don't agree on the description of the case. How do you want to move past this? This is the first objected to area. Mr. O'Sullivan, yes, I will propose further conferral. I think we should be able to agree on this. I think both sides, versions of their case is pretty clear of each other. The court, it usually is not an area of disagreement. Mr. O'Sullivan, I, again, apologize on behalf of everybody in the case. At the time this document was produced, it wasn't seamless. And things that would normally get agreed to like this didn't. And I think you've put everybody on notice that we have to get that done, and we will. The court, all right, so here's what I'm going to do. We're going to take a recess, but you're not going to take a recess. You're going to keep working. You're going to keep working with this Miss Dixon. Well, I'm sorry. You're going to keep working with Miss Dixon and her client, Miss Bien. I don't know if she's still there, in your team, and you're going to go through all of the objected areas in these jury instructions. You're going to do that in conferral today, now, and I will come back. How about if I come back at 12:15, giving you over an hour to go through these areas of objections to see where you can narrow these areas, and we'll continue trying to make progress. I want to have the jury instructions in final form before we start the trial. All right, Mr. O'Sullivan, can I make one request, Judge? The court, yes. Mr. O'Sullivan. Miss Pete flew in for this, came straight from the airport, got changed, and came here. For the part where it's just learning, would it be possible for her not to have, for her to not have to be present for that? The court, yes, she may be excused for that. Any questions? All right. So I will come back at 12:15 and you all will continue working to try to finalize the jury instructions. Mr. O'Sullivan, yes, Your Honor. The court, thank you for coming in this morning, Ms. Pete. We continue on November the 10th and your trial begins November the 17th. Ms. Pete, thank you. Okay, so recess was from 11:07 a.m. to 1:01 p.m. Okay, the court says, all right. I'm back in the courtroom. Our court reporter, for some reason, my video is not starting. I keep trying to connect so that Miss Dixon can see I'm in the courtroom, but it's not connecting. Our court reporter needs to be at a sentencing hearing at 2 p.m. So have you all completed your conferral on the disputed jury instructions or no? Miss Molino, we've gotten a lot of work done, Your Honor. There are a couple of pieces we want to discuss with Your Honor, and then a couple of pieces we haven't finished conferring on. The court, all right. Let's go as far as we can, understanding that this will have to continue then on November the 10th in part 2 of our pretrial conference. Let's begin with page 5. Description of the case. Have you all been able to reach agreement on how you want me to describe this case to the jury? Ms. Molino, we have, Your Honor. The court, all right. And then on page 6 of docket entry 139, there are objections under burden of proof. Ms. Molino, we have come to an agreement on those. The court, okay, Ms. Molino. And there are some modifications, Your Honor. I suspect you will want us to update it with the court. Yes, please. And then pages 24 and 25 have the next set of objections. Ms. Molino, on page 24, we have come to full agreement. The court, all right. Ms. Molino, on page 25, we've come to a partial agreement. The second issue of dispute in that instruction, we've come to an agreement on. The first, we require additional conferral. Ms. Dixon would like to discuss further with Mr. McLamont before we can finish that issue, but that may be an issue we have to discuss with Your Honor. The court, okay. Then the next is on page 27, clear and convincing evidence. Ms. Molino, we've come to an agreement there, Your Honor. The court, okay. Pages 28 to 34. Ms. Molino, there's parts of that where we have come to an agreement and other parts where we're still conferring. Mr. O'Sullivan, it may be just to summarize the issue. The court, can you use the microphone, Mr. O'Sullivan? I'm sorry. Mr. O'Sullivan, to summarize at least part of the part that we didn't agree on, I believe it's Ms. Dixon's contention that the concept of defamation per se does not apply to public figures, period. And we say no. That's determined by the nature of the defamation itself. In this kind of defamation, as the court decided on the motion to dismiss, is in the nature of per se. And I think it has some consequence for assumed damages in the rest of the case. But we've sent a case that supports our position, the Southern District of Florida, 2025, and we're waiting for a case from Ms. Dixon. Ms. Dixon, I did send you a case, actually. Maybe it was on the, let me see. So my issue is the use of the word defamation per se. You still have to use, you have to prove actual damages if a person is a public, the actual malice and actual damages if the person is a public figure. That's my contention, Mr. O'Sullivan. So we submit that that's just wrong on the law, that you do have to prove actual malice, but not actual damage. That's the nature of per se. Certain things are presumed to have caused damage. And then Ms. Dixon, as y'all can see there, it must have cut out. Mr. O'Sullivan, that's our position. Ms. Dixon, when it's a public figure, you have to prove both. The court, well, it's a legal question, isn't it? Mr. O'Sullivan, it is a legal question. Ms. Dixon, yes. Ms. Molino, yes, Your Honor. Ms. Dixon, can we brief that, Your Honor? Because I did have some cases and I went over it with Jeremy, but he has most of the information. The court, can we do what with that? I'm sorry, Ms. Dixon, can we brief it? The issue of whether or not it applies. Because the contention here is that if she's a public figure, actual malice applies. And then the standard of proof is clear and convincing for that. And then actual damages also apply and not nominal damages as they do in a defamation per se or not, or a private figure. The court, are there any standard jury instructions on this? Miss Milano. Unfortunately, Your Honor, the pattern jury, I'm sorry, let me scroll up. The pattern jury instructions for defamation in Florida were rescinded in 2023. They have proposed pattern instructions that have been purchased by the committee. We followed those. We followed those in proposing our defamation instruction. But to answer your question, Your Honor, there is no standing pattern instruction right now, Ms. Dixon. And the one that she's referring to doesn't really refer to defamation per se that I could see. So that's an issue because literally the page is blank when you go to the pattern jury instructions regarding defamation. So I feel like it should be brief because it's apparently something in a state of flux in the state of Florida. Mr. O'Sullivan, while you're looking, I don't know that there's any evidence that it's in a state of flux, Judge. We've given you the case that says it applies. And frankly, as you said, it's a legal matter. It was raised sort of in some way at the motion of dismiss level, basically saying that they had all these defenses as a result of being who they were. And it probably could have or should have raised a summary judgment if they wanted a legal determination that some portion of our otherwise entitlement to relief is barred. Ms. Dixon, actually, that's not. I don't see that as being the case because the fact that the pattern instructions are silent to that, that's where the issue is. I think we should brief it because apparently there is some disagreement in Florida regarding this matter. I cited the Florida Bar Committee, their recommended rules. I cited those. They don't mention defamation per se. So maybe defamation per se is not part of Florida's rules, or I don't know what it is, but it's not in there. And then the newest standard statute jury instruction is blank. It's literally blank when you go to that page. So I feel like maybe we should brief this matter merely because we disagree on it. And I don't see where is a definitive ruling since we don't have the pattern jury instructions. Because in other instances, Your Honor, when we were going over this, I conceded to them to the extent that they actually were following the pattern in jury instructions. I said, well, I don't have an issue with that. So this is where we were able to agree on things. If Jeremy had something different than what the pattern jury instructions had, then, I was saying, yeah, I agree with the pattern jury instructions. But there's nothing for me to do that. The court, well, you folks can certainly brief it. It looks like you're going to have to because you disagree on what the applicable law requires. If there is case law supporting both positions, I may give the jury alternative instructions in an alternative verdict form to answer questions so that we don't have to retry this case. There's one standard that you're to consider the evidence by. Answer these questions. Assuming this is a standard, answer these questions, and then there's no appellate issue. Mr. O'Sullivan, we agree with that, and we'll brief it. Ms. Dixon, I'll agree with that. That's one of my proposals, actually. So thank you, Your Honor. Oh, excuse me. Oh, Jesus. I agree with that. The court, the next instruction, Ms. Milano, the next instruction, Your Honor, was for intentional infliction of emotional distress. And we came to mostly agreement. There's one issue about this instruction that the parties would need Your Honor input on. The court, all right, Ms. Milano. And it's about causation, I'm sorry. Yes, the instruction that the parties have agreed to is it's the pattern instruction of intentional infliction of emotional distress. The question that we're in dispute on is which pieces of causation apply. Our instruction proposals using a concurrent causation instruction in addition to the standard legal causation one from the pattern jury instructions. And as I understand defense counsel's position, and I don't want to speak for them, there's they're asking that the court impose an intervening cause instruction and not an concurring cause instruction. The court, well, the source of the instruction is the Florida Standard Jury Instructions. What do they say, Miss Molino? The Florida Standard Jury Instructions on this case issue is, well, it says that, and then Mr. O'Sullivan says both, Your Honor. The court, I'm sorry, Miss Molino. They say that you choose which one applies in which case. The notes instruct you to say sometimes you're going to use concurring calls, sometimes you're going to use intervening calls, and it's up to which one the judge thinks is necessary. Ms. Dixon, if I may, Your Honor. The court, yes, Ms. Dixon. So the issue was there's some language, some bracketed language in, I believe it was C. If we could put it up on, could we put that up on the board like we had it before? Miss Molino. Yes. Miss Dixon. So one of them goes into causation and has to be foreseeable consequence. I would like that language to be included in the bracketed language in C. And the other issue is I don't believe it's concurrent cause. I do believe it's an intervening cause because there was several causes that Mrs. Pete had prior to. She had lost her parents. She had been bullied when she was young. She had a lot of, she has an alcohol problem. She had a lot of issues going on before she met Tory Lanez, before that issue happened in that case, and before any comments were made by milagroGramz regarding that case and subsequently regarding Miss Pete based on her involvement in that case. So I would say that I don't believe it's an concurring cause because these causes, based on her documentary, she says she had a lot of emotional distress in her family, a lot of trauma from being a young child. So I don't believe it's a concurring cause. I think it's an intervening cause because the only way that my client can be considered liable for her emotional distress is if her actions literally were a contributing factor, that intervened to cause more emotional distress than she already had. I think the resulting severe emotional distress was a reasonably foreseeable consequence. That's the bracketed part at the bottom of the extreme and outrageous conduct. And the extreme and outrageous conduct contributes. And if they can move up a little bit, yeah, to the last, there you go, substantially to producing it, that's what I wanted to see that language in there. And the last, yeah, down here too. There you go. So I just feel like that C more adequately captures this. I wouldn't disagree if they would put C as the court. I'm sorry, but why can't I give both, Mrs. Dixon? Oh, you can give both. I wouldn't disagree with that either. The court, it depends on what the jury is finding as to the facts, and this guides them. Mrs. Dixon, yes. Mr. O'Sullivan, can I explain, Your Honor? The court, sure. Mr. O'Sullivan, I think both would make sense and not be confusing if there were both issues in the case. As I understand it, we talked to Ms. Dixon about it. I don't know what they say the interview or I'm getting tongue tied, y'all. Let me hold on. Intervening cause is. In other words, in this fact pattern, chronologically, we thought that the concurrent cause instruction was necessary because they were saying her trauma and her damages are really from the shooting, not from the piling on after and during the trial. That's what we're trying to deal with. But clearly, that activity here is at the end. There's not something that happened after all of this. The court, Well, I heard Ms. Dixon talk about the parents, and I heard her talk about the issues that the plaintiff, Mr. Sullivan, chronologically earlier. The court, much earlier. There's nothing that happened after the fact, Mr. O'Sullivan, that we know of. If there's something, then I agree you would give the instruction, but I think it's confusing without them saying there's some subsequent event. Factually, what she's describing, these earlier things are sort of dealt with by the concurrent instruction. The intervening, it's just confusing. The court, right? So C requires that there be something that occurred after Mr. O'Sullivan. Yeah, the court, what occurred after? What will the evidence show occur after? Ms. Dixon, that could be a cause. Ms. Dixon, after. Well, the evidence showed that she is already suffering from emotional distress. The court, right, that wouldn't cover the use of the instruction you want me to give. What happened after your client's alleged wrongful conduct that could have contributed, Mrs. Dixon? Well, she's she's claiming that my client's conduct caused her emotional distress. I mean that she already had emotional distress. The court, what happened after your client's alleged conduct that could have contributed to or added to or caused emotional distress to the plaintiff, Mrs. Dixon? The trial, the shooting. She doesn't even know my client. So any comments that were made by my client were made as a consequence to her going to the court. What happened after your client's alleged wrongful conduct, Miss Dixon? After the court, after Miss Dixon, I don't know. They didn't show anything that happened after my client. The court. So to get this instruction, you will have to show with trial evidence that something happened after your client's alleged wrongful conduct that caused emotional distress. There's nothing in the record at this point as to any event or occurrence that happened after your client's wrongful conduct, correct? Miss Dixon. In her documentary, she states that she lost friends, that she feels like she lost boyfriends in the way that people looked at her and reacted to her. And this would be after my client's conduct, allegedly. This is after the trial and different people making statements about her, not just my client. The court. So your position is that any consequence of your client's wrongful conduct, such as losing friends and boyfriends, also constitutes a later occurrence that you can use for purposes of this instruction, like damages compounded by damages, right? Ms. Dixon. I just want to show a causation. The resulting severe emotional distress was basically foreseeable of the extreme and outrageous conduct. And the extreme and outrageous conduct produced substantially, I'm tongue tied. Substantially, I'm sorry, I keep getting tongue tied, y'all, to producing it. The court, you're not following me. I don't know if it's because you're not in my courtroom or what. So to get this instruction, there has to be some evidence that some event occurred after your client's wrongful conduct that you maintain has caused the emotional harm. Ms. Dixon, deep fake. They maintained that, not us. But they maintained in 2024 there was a deep fake video that caused her emotional distress. The court. So that's after your client's wrongful conduct, Ms. Dixon. Well, the first thing they claim as her so-called wrongful conduct is her commentary on the court. Ms. Dixon, Ms. Dixon, Ms. Dixon, please. What happened after your client's wrongful conduct, if anything, besides damage to the plaintiff by losing friends and boyfriends? Ms. Dixon. The conduct that they're mostly complaining about happened in 2022, and then they have that's the defamation. The deep fake is a whole separate the court. Ms. Dixon, can you answer my question? Do you want me to? Ms. Dixon, I did. I'm sorry if I'm being vague, but I thought I did. The deep fake happened in 2024. Most of this stuff happened in 2024, 22. The court, all right. So Your client's wrongful conduct happens in 2022. And then there's some deep fake videos that surface in 2024 that your client has nothing to do with. Is that your position? Ms. Dixon, right? The court, all right. I'll hear from plaintiff. Ms. Melino, yes, Your Honor. The deep fake, first of all, we disagree with the contention, the contention that the misconduct by the defendant is only cabin in 2022. That was an ongoing thing up until the gag order in this. The order limiting discussions outside the courtroom about this case was imposed. In deepfake, that's one of our claims was that it's part of the defendant's ongoing misconduct because she promoted the deepfake claim. That's our allegation. The court, all right. So I'm going to give to both. Well, let me repeat that. All right, so I'm going to give both of these instructions. I don't think the jury is incapable of understanding what C talks about. And I'm sure capable lawyers for the plaintiff will be able to point this out in your closing arguments as you run through these instructions to the jury. Mr. O'Sullivan, yes, Your Honor. Ms. Melino, yes, Your Honor. We'll edit. The court, all right. Next, Ms. Melino. There one other piece in the damages instruction. That's the last one. The parties have not had an opportunity to confer on that one, Your Honor, but we will before next time we meet. The court, okay. Mr. O'Sullivan, it may be we got a little farther than we were, but it's really this question of the defendants are concerned about the double counting. There's one fact pattern that these three distinct claims, and there shouldn't be double recovery. We acknowledge that the damage is kind of unified damage, and we just want to avoid confusion. We just want a clean verdict. And there really is one damage. And again, the proposal we raised with Ms. Dixon, which she's considering, is do we avoid double recovery by just having the damages at the bottom of the three? The court, that's the easiest way, certainly. You have the jury answer questions on each of your counts, right? Mr. O'Sullivan. The way it's set up now, and we even have a damage figure, I think, on each one in subsequent to the conferral. The court, no, I think you would remove the damages from each count. Mr. O'Sullivan, yes, Your Honor. The court, you would simply have the jury answering the yes or no questions on each count aside of damages. And then at the end, you will have a category of what are the damages to the plaintiff. And then you're also asking for some special and punitive damages. So you would have to have the jury write those out separately, but also at the end. Mr. O'Sullivan, one time at the bottom. The court, right. And that way there's no concern. If she prevails on one out of the three accounts, she gets that sum of money that the jury believes she's entitled to. If she prevailed on two or three of them, she gets the same pot of money. Mr. O'Sullivan. And just to kind of, it's lurking in the conferrals. But again, it's just, there is overlap. I mean, the crown jewel of the intentional infliction case is the deep fake corn. In the real world, that was the ultimate act. The court, right. Mr. O'Sullivan. But we don't, as I said, this is not so commercial. This is really getting to the truth. And we don't want to get tripped up on that. And we've offered the other side two separate ways just to avoid confusion. The court, very well. Ms. Dixon, well, I want to confer with Jeremy on it because there's an issue. I just want to confer with him because I feel there's something confusing about that, actually. So if we could put a pin in that until I've had a chance to confer. The court, of course. Hold on, y'all. Oh, excuse me. Sorry about that. Ms. Dixon, and see what his thank you. The court, and you'll have that opportunity between today and November the 10th. Ms. Dixon, thank you, Your Honor. The court, so we can finalize this as well. All right. I was in conversation with my courtroom deputy. My intention is to ask your jury pool selection. Well, ask our jury pool selection, which is understaffed right now, but most of whom are on furlough. We are still holding trials. We still we will still summon jurors. We won't pay them. Hopefully they'll get paid sometime in the future when there is a CR. But my intention was to ask for a panel of 50 or 60 jurors. Oh, it's customary in a civil trial to ask for a panel of 18, just so you are aware. But given that I'm sure we want to weed out people that know something about the case and have views about the case and who have views about the parties, that it makes sense to bring an extra large group so that we can hopefully avoid having to go through more than one jury selection. What are the parties' views on that, Mr. O'Sullivan? The plaintiff would be in favor of having a bigger pool. We will try to do a good job on any questionnaire things that can maybe narrow it. But yes, I think I actually don't know what to expect in terms of how much awareness there is to the facts. But there is some out there, I realize. So we would be in favor of that. The court. So we have a sample, a civil juror questionnaire form. Do you all have that? You do? Okay. Now, we're at the end of part 3. I will see y'all on part 4. Take care.